million in respect of the July 2014 contract. Now, I'll repeat it here. I refused to order from that contract because the experts were never going to use that camera. How do I order something that is going to be a white elephant? They were never going to be able to utilize the cameras. So fast forward, having refused, and even people after me in forensic services refused and say, we can't order this thing. We are not going to need it. I saved the department 92 million. That could have used to buy cameras that were never going to be used. Beyond me, remember I say I signed and approved that the independent assessment must be done based on the advice of National Treasury also. Even us as forensic services, there is a letter there, 29 April 2016, which is saying, take it for independent assessment and we will pay. In other words, forensic services was even prepared to pay for the independent assessment. To date, it did not happen. Come the 1st of June 2017, I'm out of office. Having directed that you must still do independent assessment, defend the litigation, because at the time there was an email from Etemba saying, we now want these, they were now demanding 14 million to say, because you did not order for our damages to bid and so on, pay us 14 million. I don't know what happened, because since the 1st of June 2017, I'm involved nowhere. They go on, then there is a settlement, which is signed by General Setole to say, let's settle for the no more than 14 million. When I was in office, I saw them asking for 14 million, but they settle to pay 24 million. Now, I don't know how long it took to settle the 24 million, because they 7 million extra that they paid for interest. Now, Honorable Chair, my question is, I'm not going into the merits of the dismissal or whatever. My question is, what do I have to do with payment that was settled by General Setole in 2018, 2019, when I'm long out of office, despite the fact that everyone consistently in forensic services was opposing and say, we can't pay. No one of forensic services was involved in a litigation, deliberately excluded. And when they pay, after they paid, that's when they come running to me and say, you cost the state 24 million rands loss.
General Phahlane, I don't disagree with your narrative. That's why I asked you if we can agree that whether it's the 92 million or whether it's the 24 million award of Judge Harms, it's about the same contract. Yeah, can we agree that?
Well, if you want me to say it for the sake of saying it, I agree, we can move.
Okay. A reluctant yes,
It's not reluctant. I've
No,
already expressed myself
simple.
there. I
We're getting
agree,
stuck on
I have
this.
explained the context, because the context was wrong.
And the reasons, the reason why the arbitrator found your dismissal procedurally and substantively fair are reasons which are not part of the award of Judge Harms of the 24 million. They are completely separate. That is, the 24 million is after there'd been demands made by the successful bidder. It was made clear to them that SAPS made it clear to them we're not going to honor this contract, so what they call repudiated the contract. And at the end of the day, Itembu sued and said, look, these are the damages that we suffered. We also know from the award that at the arbitration, SAPs were not even represented there at the arbitration. They didn't have any witnesses there, and their counsel complained that they didn't have an instruction. And LTC Harms then said, in that case, I'm making the award. Now that is separate from the 92 million. But we're talking about the same contract. Okay? And I accept that that settlement agreement was signed by National Commissioner Satori at the time and had nothing to do with you. Okay? So as far as your dismissal and the reason for your dismissal are concerned, you've taken that as far as you can so far, and there's a judgment outstanding. The 92 million contract, or at the time the full contract that was before the arbitrator, that related to your, let's call it, alleged conduct or misconduct in the process of that tender. It didn't, and to put it again also on the record, at that time it didn't involve any dishonesty on your part. The arbitrator found that your conduct was reckless. That is what the arbitrator found. Okay. So can we move on from there? But the contract itself, it does feature later on in this whole narrative for other reasons.
Am
We can deal with them.
Am I allowed to
Of
talk?
course.
Paragraph 41. Even the acting judge at the Labour Court found no element of dishonesty that Lieutenant General Reid attributed to me, and the learned judge ought to have found that the commissioner completely ignored or failed to deal with material information placed before her. That's on page 17, paragraph 41. The learned judge also found that my dismissal was procedurally and substantively fair on charge 1, only one charge. With the leave of the Labour Appeal Court, my application for leave to appeal was granted, and the appeal was heard on 16 September 2025. To date, we wait for the judgment of the LAC. I'm also awaiting the outcome of an investigation conducted by the Public Protector of South Africa on the complaint I lodged in relation hereto, registered with since 2022. 4 years later, I'm still waiting. So I really have run out of the appetite of dealing with that matter because it's very well covered in my affidavit, and there is no distinction between the Harams award and the contract that was awarded in July 2014 by Supply Chain Management. The payment emanates, which follows Haram's judgment, is on the same 92 million contract, which for record purposes, once again, I had spent no cent on that particular contract.
I accept that in relation to that 92 million rand contract, your view was that the successful bidder should not have been awarded the contract because the product was defective. That's what you said.
Chair, I want to disagree with your view because that is the narrative that has been peddled outside. Your view, it is said, I did not agree with that contract because it was not awarded to FDA. So if you say my view, I disagree. The view of forensic services led by me is that that contract was not compliant and the record speaks for themselves.
Again, General Phahlane, let me not be quoted because I'm referring only to judgments that that had been handed down. And in the in your application for leave to appeal, that judgment is also in the bundle. It's in our bundle. It's in not in the bundle. In the exhibit bundle. When you applied for leave to appeal, and what page is it? It's item number 6. Where is the exhibit blanket? But can I refer you to paragraph 26? It's on page 11 of the judgment. You see that? The applicant's conduct did not need to amount to serious insubordination, for it constituted serious misconduct. Regulation 9 sets out serious acts of misconduct to include serious insubordination or similar misconduct. Having considered the evidence, I'm satisfied that the applicant's conduct amounted to similar misconduct and that it constituted serious misconduct. And then later on at paragraph 33, and this is in relation to the 24 million, the LTC Arms award. Although the applicant was not involved in the settlement process, he set in motion the sequence of events that led to the first respondent, breaching the contract with EFG, that's the successful body bidder, and ultimately resulted in EFG having a claim for breach of contract against the first respondent. This ultimately resulted in the first respondent paying EFG an amount of 24,494,000. Again, that's what I'm reading to you. That's what a judge found.
Judge who?
Sorry?
Judge?
Judge Davey.
Oh.
Acting
All
Judge
right.
Davey.
Chair, ordinarily, I will not want to dignify what that judge wrote there out of respect for the judiciary. Because if this was to be correct, it is me who on the 22nd of October 2014 sent supply chain management in response that you have awarded a contract to a bidder whose product doesn't meet the specifications. It is me on the 4th of November that I write again to supply chain management after I called the two. Maybe you will tell me when you are to listen to me. Chair, I'm responding to questions. I suspect that I'm to be listened to by the person who asks questions. It's me who in November 2014 that I respond to supply chain management after I called the service providers, that is Atemba and FDA, to come and demonstrate the capability of their cameras. I'm not alone. I'm with management of forensic services. That presentation satisfied me that the response I got from the expert, which said the camera doesn't meet the specifications, then gets demonstrated to me on the 28th of October 2014 by the same service provider, Atemba. And I saw it with my naked eye, the stitching and the non-compliance which is happening. On the 10th of May of March 2015, I write to supply chain management a comprehensive letter, which is say, please subject this product to an independent assessment. On the 29th of April 2016, the divisional commissioner acting writes to supply chain management and say, this product doesn't meet the specifications. Therefore, we can't buy. We even make an offer in that letter to say, subject this thing to an independent assessment and we'll pay. 29th of September 2016, National Treasury responds and say to supply chain management, subject this thing to an independent assessment with CSIR and what is it, South African Bureau of Standards. 23 November 2016, in my capacity as an acting national commissioner, I approve and say, subject this thing to an independent assessment. It's not me who wrote, it's supply chain management after they receive the National Treasury letter. And then I later leave. Was it only going to be satisfactory if we have ordered? So this judge who's writing here, must I respond? Was it going to be acceptable for us to have spent 92 million on a non-compliant contract? I will be dancing a different tune today. It will not only have been this concocted disciplinary, I'll be parading before the courts to say corruption, corruption. If I said to my people, buy, they are telling me they are experts. I'm not an expert. They are saying, we are not going to be able to use this thing. Now, consistently, you are being told, buy, buy, buy. Just now, there is a discussion on the 360. I don't know why is it also 360. 360 million of, what is it, Medicare 24, the Mr. Ket Matlala's contract. Why is that contract cancelled so shortly after the allegations that it doesn't meet the specifications? Why is this 92 million rands not cancelled, despite us, the experts, say that camera we are not going to be able to use? Is it not supposed to follow the same process? There is clause number 2.7 of the general conditions of contract management, which tells you what process must be followed once there is an issue. So, Chair, I see, I can't help you. I'm not going to dignify this judge's comments with a response. That's why they are before the Labour Appeals Court. Let's wait for the Labour Appeals Court to pronounce. I'm not going to spend my energy on that person.
Can we please take Honorable James? There is a microphone there. The microphone behind you is on. If you can please help to